In a dramatic legal twist, Prince Harry finds himself embroiled in yet another battle, this time against a powerful American conservative think tank. The Heritage Foundation, a Washington, D.C. based group known for its focus on U.S. legal policy, has reignited its quest to make the Duke of Sussex's U.S. visa application public. Their argument stems from Prince Harry's bombshell admissions in his memoir Spare, where he openly discusses his past drug use. Despite losing an earlier court case to access the Duke's immigration records, Heritage is now determined to reopen the matter, raising fresh questions about Prince Harry's U.S. residency and what the Biden administration may have concealed in the process. The Heritage Foundation's relentless pursuit of Prince Harry's visa documents has not only made headlines but also brought attention to the complex intersections of privacy, immigration law, and public interest in the lives of high-profile figures. As the legal drama unfolds, the think tank's latest court filing signals a renewed determination to uncover what they believe are inconsistencies in the handling of the Duke's visa. Will the public finally gain access to Prince Harry's immigration secrets, or will his right to privacy prevail once more? This legal saga promises to be another chapter in the Duke's complicated relationship with the U.S. and the media. The Heritage Foundation's initial lawsuit and its fallout. The controversy surrounding Prince Harry's U.S. visa application began in early 2023, shortly after the release of his memoir Spare. In the book, the Duke of Sussex admits to using a range of drugs, including cocaine, marijuana, and psychedelic mushrooms, during various stages of his life. These revelations, while shocking to some, prompted legal scrutiny from the Heritage Foundation, which quickly questioned why the Duke was allowed entry into the U.S. in the first place. According to U.S. immigration law, visa applicants are required to declare any history of drug use, and such admissions can result in inadmissibility to the country. In May 2023, the think tank filed a lawsuit against the Department of Homeland Security, DHS, after its Freedom of Information Act, FOIA, request for Prince Harry's visa records was denied. The organization argued that the public had a right to know whether Harry had been truthful in his visa application about his drug use and whether the U.S. government had shown preferential treatment to the Duke. The legal battle culminated on September 23, when Judge Carl Nichols ruled against the Heritage Foundation, stating that Prince Harry's immigration records would remain private. In his ruling, Judge Nichols emphasized that the Duke's privacy rights outweighed any public interest in his immigration status. He further noted that public disclosure of a single individual's immigration records would provide minimal insight into the government's broader policy on admitting foreign nationals. Additionally, the judge clarified that Prince Harry's public statements regarding his drug use did not nullify his privacy rights in matters related to his visa application. Despite this legal setback, the Heritage Foundation was not ready to back down. Citing concerns over what they viewed as a lack of transparency and potential government misconduct, the think tank vowed to explore further legal avenues. Heritage's renewed legal push, a quest for transparency. Now, just weeks after their initial defeat, the Heritage Foundation has filed a 13-page motion in federal court, seeking to vacate the previous ruling and reopen the case. In their latest filing, Heritage argues that they were not afforded the opportunity to view private submissions made by the Biden administration to the judge, which they claim severely compromised their ability to present an effective appeal. Central to the think tank's argument is their belief that certain facts surrounding Prince Harry's immigration status were redacted in a way that undermined the transparency of the judicial process. According to the filing, these redactions included information that the Duke has not disclosed publicly, such as specific details regarding his visa application and whether he had declared his past drug use. Heritage's lawyers have claimed that this level of secrecy has left them in a fog of uncertainty, preventing them from fully understanding the DHS's role in granting the Duke of Sussex entry into the United States. Heritage's legal team also raised the issue of potential agency bad faith, accusing the U.S. government of withholding information and arguing that such actions are not consistent with the adversarial nature of the U.S. legal system. The think tank insists that the public has a right to scrutinize how high-profile figures are treated in matters of immigration, particularly when it comes to questions of legality and integrity. One of Heritage's most significant concerns is the notion that the U.S. government may have granted Prince Harry special privileges due to his royal status. The group argues that if this were true, It would raise serious ethical questions about the consistency of U.S. immigration policies, which are supposed to apply equally to all applicants, regardless of wealth, fame, or position. In their latest motion, Heritage's legal team pointed out that Prince Harry's case is unique and fraught with complexities, but that should not exempt it from public scrutiny. They reiterated their belief that transparency in the Duke's visa application process is crucial to maintaining the integrity of the U.S. immigration system. Heritage lawyers further stated that they are not alleging any specific wrongdoing but are simply requesting a full review of the case to determine whether the proper protocols were followed. The privacy versus public interest debate. What's at stake? At the heart of this legal battle lies a fundamental tension between privacy rights and the public's right to know. On one hand, Prince Harry, like any foreign national, is entitled to a degree of privacy when it comes to his immigration status. Immigration records, much like health or financial information, are generally considered private personal data. In fact, U.S. immigration law protects the confidentiality of visa applicants' information to prevent unnecessary public exposure. On the other hand, the Heritage Foundation argues that Prince Harry's public admissions in his memoir have created a legitimate public interest in his visa application. They contend that because the Duke has spoken so openly about his past drug use, there is a valid question as to whether he properly disclosed this information when applying for his U.S. visa. The think tank believes that the public deserves to know whether the U.S. government acted appropriately in granting Harry entry into the country. The stakes are high for both sides. For Prince Harry, a ruling in favor of Heritage could potentially result in the release of sensitive personal information, including details about his immigration status that have not been made public. Such a ruling could also lead to further legal challenges and public scrutiny, potentially putting his residency in the U.S. at risk. For the Heritage Foundation, a victory would not only represent a triumph for transparency and accountability but could also set a legal precedent for how immigration records are handled in cases involving high-profile individuals. What Prince Harry's memoir revealed. In Spare, Prince Harry provides a candid account of his life, from his struggles with grief following the death of his mother, Princess Diana, to his experiences with substance abuse. One of the most shocking revelations in the memoir was Harry's admission that he had experimented with drugs, including cocaine, marijuana, and psychedelic mushrooms. While the Duke downplayed the significance of his cocaine use, stating that the drug didn't do anything for me, he was more positive about his experiences with marijuana, which he claimed helped him cope with emotional distress. These admissions have led some critics to question whether the Duke violated U.S. immigration law by failing to declare his drug use in his visa application. According to U.S. law, foreign nationals who admit to drug use can be deemed inadmissible to the country, even if they have not been convicted of a crime. However, there are exceptions to this rule, and immigration officials have broad discretion in determining whether an applicant should be granted a visa. In Harry's case, it is unclear whether his past drug use played any role in the decision to allow him entry into the U.S. The Biden administration's defense and Heritage's response. In response to Heritage's legal claims, the Biden administration has vigorously defended its handling of the Duke's visa application. In court filings, lawyers representing the DHS argued that Prince Harry's immigration records are private and should not be disclosed to the public. They also noted that there is no evidence that the Duke was ever convicted of a drug-related offense, and that any suggestion of wrongdoing on the part of the U.S. government is purely speculative. John Bardo, a lawyer for the DHS, emphasized that immigration records are protected by law and that disclosing them would set a dangerous precedent. He argued that revealing details about a single individual's immigration status would provide little benefit to the public and could undermine the privacy rights of visa applicants in future cases. Heritage, however, remains undeterred. In their latest court filing, the think tank doubled down on their argument that the public has a right to know how the U.S. government handled Prince Harry's visa application, particularly in light of his drug admissions. They claim that the DHS's refusal to release the records raises questions about the integrity of the immigration process and the potential for preferential treatment. What lies ahead for Prince Harry? As the legal battle over Prince Harry's visa application intensifies, the outcome remains uncertain. For the Duke of Sussex, this case represents yet another challenge in his quest for privacy and autonomy, especially as he continues to navigate life outside the British royal family. For the Heritage Foundation, it is a matter of principle, a fight for transparency and accountability in the U.S. legal system. While Judge Nichols' original ruling favored the Duke's privacy rights, Heritage's renewed legal push has reignited public interest in the case, and it remains to be seen whether the court will reconsider its decision. If the case is reopened, it could lead to further revelations about Prince Harry's immigration status and the U.S. government's handling.